This afternoon, the Politics Department and the William Lyon Wilson II Symposium Fund are sponsoring our annual Constitution Day speaker. I want to say a special word of welcome to our guests from VMI who are here this afternoon, and I want to let the audience know that if any of the cadets have to get up and leave early, it's not because they have any reservations about the Constitution. It's because they have a parade ceremony later this afternoon that they have to be ready for. Our speaker this afternoon is going to be introduced by Mark Bradley, and I have the honor of introducing Mark. He's a graduate of Washington Lee in 1978. He went on to earn an additional degree in history, I believe, at Oxford University. Later, he attended law school at the University of Virginia. He has had a fascinating and varied career. He's worked in the intelligence community in Afghanistan. He was chief of staff for Senator Moynihan on Capitol Hill. He has, for a number of years, worked in the Justice Department, first on issues related to counterterrorism, now on the Freedom of Information Act and the classification system. So it gives me great pleasure to invite to the podium Mark Bradley.
Thank you so much for coming. As I tell people all the time, it's so nice to be out of Washington, that city that Jack Kennedy said, the city of northern charm and southern efficiency. And it's funny to come back to a place where they say, do you want sweet tea or regular tea? People stop in the crosswalks as you walk across and actually speak. It's always like returning home, and I can't be more honored and thrilled to come back, especially for this occasion. I want to congratulate the university, particularly Bob in particular, and the university in general, for having the foresight to introduce or to invite such a distinguished speaker today as Professor A.E. Dick Howard. I've known Dick for 30 years, and I want to say that out of all the people I have worked with and had the pleasure of actually knowing, that Dick reminds me the most of my late boss and mentor, Daniel Patrick Moynihan, because Dick is what's called, I think, a public intellectual. Not only one who teaches and writes, but actually acts upon what he's thinking about. His record has been extraordinary, really. Let me segue for a minute, too. I wanted to say one of his greatest accomplishments was marrying this young lady here, Mary Howard. Mary, welcome to Lexington. I hope you'll find our architecture as interesting as Charlottesville's. Mary's an architectural preservationist and actually won the Peterson Award from the National Historic Building Survey for a drawing on the pavilion. So if you'd like to draw our colonnade, we'd be welcome, or even the Institute. So please, welcome. Anyway, back to Dick. If you look at his record, it's been astonishing, not only locally, but also nationally. He, and I don't want to just recite what's already been known, but let me just highlight a couple things. His being chair of the actual director of the commission that wrote our current Virginia Constitution, legal advisor to the Virginia General Assembly, which must be like dealing with the Balkans, frankly. His work with the Senate Judiciary Committee, his work with the Bicentennial Committee, has all been astonishing. But you know, it's funny, I keep waiting for him to peak and to reach his zenith, and it still hasn't happened. I think probably his most interesting work and most distinguished work is what's been happening over the last 15 to 20 years. And that is his work on constitutions around the world. I count 11 constitutions in 3 continents. What's interesting about that is, you know, we export a lot of things as Americans. Probably our 3 most successful have been baseball, Coca-Cola, and constitutions. And what's interesting about the constitutions that Dick has worked on is he's been able to take them and tailor them to each individual country or area's history and ethnicity. What's so extraordinary about that is that I believe, being the national security field, that most people will commit acts of terror or begin to think about them if they feel disenfranchised or don't have a stake in the society. And one of the ways to give them a stake in a society is to have an honest-to-God working constitution, which is balanced, where people feel they have redress if they don't like what they see. Instead of grabbing a rifle or a Molotov cocktail, you can go to court or you can vote for somebody and change the system. I have no doubt that Dick's work has probably not only made us a safer country because of the way that he's been able to export this doctrine, but also it's saved lives. The topic today of Dick's talk, changing face of the Supreme Court. It's funny, as a Washingtonian now, it seems to me that we have more of a divided and subdivided government than we do a balanced government. And that's worrisome. It's worrisome for any number of reasons. I've always thought that our greatest strength as a people is that we're moderate, we're temperate. And it worries me that we're getting into more extremes. It also, too, I'm beginning to detect a rising sense of xenophobia again in the country. That's probably not unnatural as the economy worsens. If you look at our history, that's what we normally do. We go after groups who are weaker than ourselves, which is disturbing. But secondly, it makes us more, I think, unable to respond to an attack if and when it does come. And I should strike if and say when it comes. It worries me how we're going to react. Hopefully we'll appeal to the better angels of our nature and do the right thing. Usually we don't, but we have a Supreme Court that fixes it down the line. In the meantime, though, Congress seems to play its fiddle as Rome burns. The current administration is left with tremendous problems, but also seems to find that being in power is not as easy as being in opposition. That's kind of a common theme for any government. I think out of all three branches of government, probably the one that's at the highest tide right now is the Supreme Court. The problem is, as I'm sure Dick will illuminate as we talk about the changing of the face of the Supreme Court, is it's also so sharply divided. It's not unusual, I suppose, for a government institution to reflect politics at large and also the people at large, but it's worrisome. Hopefully, Dick, you can put me at ease as a national security type and tell me that we're going to be a more moderate people as we go forward, and that the court will quit being so divisive and more centered. I hope so. I think we're basically a centrist people, and I'd like to see us stay there. Anyway, you didn't come to hear me. You came to hear probably, I think, maybe if not the greatest authority in the United States Constitution, certainly one of a handful. So you're in for a real treat, and I am delighted to introduce Professor A.E. Dick Howard.
Thank you, Mark. Thank you so much. What a lovely and gracious introduction. I always hesitate when I have a former student on the platform introducing me, because once they've graduated and have gotten their degree, then there are no holds barred, and you worry that they may remember the grade that you thought was perfectly adequate and they thought was not good enough, and they may nurture a grievance after all these years. But the wonderful thing is they go on to do such great things, they basically forget the grievance, and it becomes kind of, as distance puts itself between you and your degree, your memories become fond ones. And I'm like most professors, I have a selective memory of my students, and I always remember fondly the ones that have done great things and conveniently forget the others. So Mark is clearly not one of the ones I've forgotten. It is, as you know, Constitution Day 2010. Once a year, you like to think the people of America take the occasion to pause and take stock of their constitutional heritage. The Constitution ordains, as you know, three branches of government, and you'll be relieved to know that I don't plan to talk about two of them. That shortens the lecture considerably. We might be here a long time if I had to walk through all three branches. And indeed, the one I will talk about has had a history of, 220 odd years, and I will only talk about the last 40 years, so I think I'll get you out of here in good time. I recognize, by the way, our good friends from VMI, some of you may have to leave early. What a convenient cover, because the rest of you, if you leave early, you don't have that same excuse. I'll take it personally if you all walk out on me. But I thank all of you for coming. It really is great to see you. I want to talk about the Supreme Court. I've called it the changing face of the Supreme Court. And I want to focus in on what's been happening essentially since the time of the so-called Warren Court in the 1960s to the present time. I mean, it's a period of years, but it's a chapter, in effect, in the Supreme Court's history. Most of you will not remember the Warren Court personally, but you've probably read about it. It was a remarkably activist period, almost breathtaking in its social engineering. It gave us one person, one vote. It revolutionized and nationalized criminal justice. It gave us, in many ways, supported and propelled the modern civil rights movement. It sparked what we now call the right of privacy. I mean, it was really quite a remarkable agenda. And for those of you who are students of the law, you might probably agree that the Warren Court was not inclined to sort of spend much time worrying about legal technicalities. I mean, it was really more inclined to, do the right thing. If it saw a problem, it solved it. And it was out to sort of see results happen, and legal reasoning it could leave to professors like me. Well, as a result of that, the Warren Court achieved a lot if you were friendly to it. If you were critical of it, you probably thought, well, wait a minute, we're supposed to be a self-governing people. You know, who are these 9 judges to tell us how to run the country? I remember one wag who made the comment that if the road to hell is paved with good intentions, the Warren Court must be one of the great road builders of all time. And I think you get the drift. This was the kind of conservative critique which also echoed in Richard Nixon's first successful race for the presidency. Now, that was 1968, and Nixon went around the country beating up on the Warren Court. He basically charged the court with coddling communists and criminals and turning God out of the classroom and not caring about good, God-fearing, tax-paying citizens. And he said, look, elect me as president, and I'll do something about it. I mean, I'm going to change things because I'm going to put judicial conservatives on the U.S. Supreme Court. Well, Nixon was elected, and then it turned out in the first term, and indeed about the first 2.5 years of the first term, that there were 4 vacancies on the court. I mean, there are only 9 seats, so I mean, that's a remarkable turnover in a short time. So obviously the country were on the edges of their collective seats, wondering what Nixon would do to redeem his campaign promise to change the face of the court. Well, if you remember that period, you know there were a couple of stumbles. Nixon had a so-called Southern strategy. He wanted to get a good Southerner on the court with the next presidential election in mind. He thought Southern votes would count in 1972. And he gave us, for example, I doubt anybody in the room remembers the name G. Harold Carswell. You remember G. Harold Carswell? He was a federal judge in Florida who wasn't fit to sit on the district court, much less on the U.S. Supreme Court. So that fizzled and failed. But finally, of course, Nixon put 4 people on the court. Warren Burger as Chief Justice, Harry Blackmun, also from Minnesota, on the court. Lewis Powell, Washington and Lee graduate. A moment of respect, if you will, please, for Washington and Lee's contribution to the U.S. Supreme Court. And William Rehnquist, who later became Chief Justice. So by January of 1962, you now had 4 Nixon appointees on the court. And of course, people started talking about the Nixon court. Herblock in the Washington Post had a cartoon that showed all the members of the Supreme Court in black robes, all wearing Nixon face masks. Imagine how scary that was to more liberal citizens. So the Nixon court, well, as time passed, people stopped talking about a Nixon court. It began to be called simply the Burger Court. And if you measure the history of the Burger Court from 1969 to 1986, when Warren Burger stepped down, it really turned out not to be all that different from the Warren Court. It was not a wrecking crew. They didn't overturn the Warren Court's legacy. They didn't overturn those precedents that I just mentioned. Indeed, if judicial activism means finding more work for judges to do, the Burger Court did that big time, because they were the ones that gave us Exhibit A would be Roe versus Wade, right? The abortion decision. Not a Warren Court decision, but a Burger Court decision. A lot of other examples I could give you, but by the 1980s, at the end of the Burger Court, imagine the frustration, the consternation of conservatives who were upset about the Warren Court. And here was the Burger Court doing more of the same. Things were getting worse, not better. Well, these were the Reagan years, and I think from 1980 you can certainly measure a political shift in the American landscape. With Ronald Reagan in office, what I think happened then vis-a-vis the court was that, nominations to the court have always been political. You expect Democrats to pick Democrats and Republicans to pick Republicans, but that was old-style politics. You had Harry Truman, who picked his poker-playing buddies to be on the Supreme Court. Burton and Minton, for example, eminently forgettable justices. Jack Kennedy, who put the great football hero, so-called Whizzer White, on the court. And I don't think Jack Kennedy much cared what Byron White's judicial philosophy was. He was an All-American Heisman Trophy winner, the kind of guy you'd like to toss a football around with at Hyannisport, you know, his kind of guy, so he put him on the Supreme Court. That's the old politics. The new politics, as of the Reagan years and after, was politics morphed into ideology. Now you had the Justice Department carefully sifting the potential voting records of nominees, with the result that you get, for example, in 1986, you get Rehnquist promoted to be Chief Justice. In 1987, some of you will remember the Bork hearings, the Robert Bork hearings. McNeil Lehrer asked me to go up and do commentary, gavel-to-gavel commentary on those hearings. And frankly, I went up with sort of a sinking heart because I thought it'd be really pretty boring. Well, boring. It was guerrilla theater. I mean, if you remember even if you didn't remember them, if you've seen clips of them, here you had Robert Bork, this sort of jaded, brilliant, somewhat arrogant law professor. What can I say? I mean, law professors think they're brilliant, and they sometimes are arrogant. Here's Bork, you know, who knew he was smarter than all the members of the Judiciary Committee put together. Well, I don't know. My advice would be, if you're ever nominated, those of you who are students and go on to do great things, if you're ever in front of the Judiciary Committee, I think a little humility would go a long way. You know, you may be smarter than they are, but I don't think I'd let on. I just kind of go with the flow and tug the forelock a little bit. Anyway, here's Bork, you know, going mano a mano with the committee, and he finally went down in flames. Well, he was then replaced by Anthony Kennedy. So Reagan put 3 people on the court. Then you go into the Bush 1 years, 2 nominees, David Souter, the stealth candidate. I hadn't met David Souter until I, again, covered those hearings from McNeil Lehrer. I got to know him later on. All we knew about David Souter at the time of his nomination was, first, that he walked an elderly neighbor to church on Sunday, and secondly, that he had for lunch an apple and yogurt. That was it. Talk about New England minimalism. Oh, and I got to know David Souter. At one point, he invited me to lunch. Well, I jumped on the invitation. I didn't want to talk about the court and about cases. I wanted to see what he had for lunch, right? And only he had what it was predicted, but no apple. Just a bowl of yogurt, that was it. Well, so New England to the core. The other Bush nominee was Clarence Thomas, also famously controversial. But by that point, you now have an emerging conservative, not a majority, but a core of at least 3 conservatives on the court. The Chief Justice Rehnquist, and you now have Scalia, the Reagan nominee, and Thomas. So you're kind of beginning to edge towards what the conservative counter-revolution was meant to be all about. Clinton then put 2 people on the court, Breyer and Ginsburg, moderate liberals, Democrats. And then things settled in for, 11 years, 1994 to 2005, the second longest period in the history of the U.S. Supreme Court without a vacancy on the court. So that was the late Rehnquist court. By then, you could begin to generalize about what the court was doing. And at 2005, I'm going to hold off for just a moment because I want to talk about the Roberts Court, the present court, in a minute. But first, I want to say something about what the court, what we might say about that legacy of the Rehnquist years, this long period from 1986 to 2005, because this was beginning the emergent conservative majority. Just to give a couple of examples of the significant changes that took place, one would be the changes in federalism. I don't know if you've read the Constitution lately, but the 10th Amendment is the one that says all rights not delegated to the federal government are reserved to the states. The Warren Court read the 10th Amendment out of the Constitution. The Warren Court didn't care about the states. Indeed, they thought the states were the problem. So they deferred to national power. It was the Rehnquist court that brought the 10th Amendment back. If there are any law students here, you'll know about the 1995 decision in the Lopez case. I had taught generations of students, some of whom are here, who will remember me saying, you will never live to see the day when the U.S. Supreme Court will hold that Congress has exceeded its commerce power. It won't happen. Well, 1995, along came U.S. versus Lopez, in which the court did exactly what I said it would never do. The Gun-Free School Zone Act, it was held, exceeded the commerce power. So, and the court didn't have the good grace to wait until my teaching semester was over. I had to go back in the classroom and confess, say, remember what I told you? I lied. They did exactly what I said they wouldn't do. So federalism is back, thanks to the Rehnquist Court. Second example would be church and state. The Warren and Burger courts believed mightily, I think, in the principle of separation of church and state and enforced that through a number of rulings, like school prayer rulings. And starting in about 1985, I think we've seen an erosion of that principle in which the court has steadily made it easier for government and religion to interact. They haven't dismantled the wall entirely, but it's certainly missing a lot of bricks. That would be, a third example might be criminal justice, Miranda and interrogations and criminal procedure rules. I think the court has shifted substantially to the right. Well, I could give you a lot of examples like that. I think the argument that has gone on in recent years in the court is in good part over what Justice William Brennan used to call the living Constitution. Brennan's picture of the Constitution, he was a Warren Court activist liberal. His picture was of an organic document that continues to develop and sort of pick up meaning with each generation. And that's opposed, as I'm sure you know, by Scalia and others who say, no, we have to look at the Constitution and what it meant when it was written by those who understood it at that time. If it meant X then, it means X now. If you want to change it, amend it. But the court has this living Constitution stuff simply empowers judicial activists. Well, those are some of the arguments that go on. What I want to talk about a little bit, because to me the changing face of the court includes thinking about the personalities and the process. I mean, these are 9 people, and they carry with them a lot of the human baggage that 9 people do. They may be, more elevated than the rest of us because they now are on the Supreme Court, but they are a small collective body that has to do business together. So several observations about changes in the Supreme Court between the Warren era in the 60s and the present time. First one would be obvious, I think, and that is a generational change. Complete turnover in the court. There's no one left on the present court who was there in the Warren court. Now that means more than you might suppose, because it is true that there's still a conservative wing and a liberal wing, but the so-called liberal wing on the present court is not a Warren court liberal wing. It's more moderate liberalism. There are no William Brennans or Thurgood Marshalls on the present court. Secondly is about the background of the justices. I clerked for Hugo Black in the 1960s. And at that time, the court had a number of members who had made their mark in national politics and affairs before they ever came on the Supreme Court. I mean, these were people you'd heard of before they were nominated. I mean, Earl Warren had been governor of California on a vice presidential ticket. Hugo Black had been a New Deal senator from Alabama. William O. Douglas had been chairman of the Securities and Exchange Commission. Felix Frankfurter had been one of Roosevelt's closest advisors. Arthur Goldberg had been Secretary of Labor, AFL-CIO General Counsel. I mean, these were people who cast shadows, but they also had experience in the world of politics and affairs. Now, that has changed completely. The present court, with the sole exception of Elena Kagan, who takes her seat this fall, with the sole exception of Kagan, all of the members of the court came to the court from the appellate bench. They were Court of Appeals judges before they came to the Supreme Court. Not only that, there's no one on the court, and this includes Kagan, who has held any elective office, state or federal, at any level, none whatever. None has held high appointed position in the federal or state governments. You just don't have people who've been out there and mixed it up in politics. Now, what does that mean? It means you have very smart, very bright, technically accomplished judges with a narrow professional background. I think something gets lost there. I think Senator Moynihan would appreciate this. For one, I think if he were standing here, he'd make the same observation, that the court is healthier when you have people, some of whom have been out there in the world of politics and really know what it's all about. So that's a major change. Thirdly, the court's demography has changed. It's a much more diverse court. It may lack political experience, but on the other hand, we now have women on the court, which the Warren Court did not have. We have Hispanics on the court. So in many ways, it represents the country. Geographically diverse, it is not. In the 19th century, it was assumed that the court had to sort of represent all the regions of the country. And that is manifestly no longer true. You had, at one point, 2 justices from Arizona, another point 2 from Minnesota. I have nothing against those states, but you know, what did they do to earn 2 places on the U.S. Supreme Court? Indeed, when the court sits this fall, think about I don't know if any of you are from New York City or not, but 4 of the 5 boroughs of New York City will be represented on the U.S. Supreme Court. Now, what do you make of that? The only one that gets left out is poor old Staten Island. Oh, poor Staten Island always gets dissed by the rest of New York, so it doesn't have a seat. But all the other boroughs do. Now, I don't know, what did New York do to get 4 out of 9, New York City to get 4 out of 9 seats on the court? Religion is interesting. When Earl Warren stepped down from the court in 1969, 7 of the 9 justices were Protestant. And 5 of those 7 were either Presbyterian or Episcopalian. 1969, just over 40 years ago. When the court sits in October, it will have 6 Catholics and 3 Jews and no Protestants. Well, you know, that's okay. I don't think it's going to do the country any damage. But isn't it a remarkable commentary on the changing face of the court, given the sort of mainstream Protestant history of America for most of its history? Now, I'm not going to suggest that that's going to make a difference in what the court's decisions are. I think that would be silly of me. But I just think it's an interesting demographic fact. Fourth change that I want to comment on is the confirmation process. I mentioned the Bork hearings. It used to be, it wasn't until 1953 that nominees to the court regularly came before the Senate Judiciary Committee. When William O. Douglas got the call from the White House that Roosevelt was going to put him on the court, it was only 12 days until, by a voice vote, the Senate confirmed him. 12 days. I mean, it's unimaginable today. Today, you get nominated and vetted and go before the committee and asked all kinds of questions. It's a very combative process. And thanks in good part to the Bork hearings, it is now in good part, a circus. And you all have watched these hearings, and you've got this kabuki dance that goes on with the senators on the one side asking all these impossible questions, which they know won't be answered, and the nominee on the other hand. There are 2 things a nominee can do. Ginsburg perfected this technique. Some questions will be thought to be too general, therefore hypothetical, and the nominee will politely say, but I don't do hypotheticals. But then on the other hand, if you get too specific, the nominee will say, oh no, Senator, with all respect, that could come before the court, and I can't take a position on that. Well, there's nothing left, right? Except maybe name and social security number or something. But so nothing happens of substance in these hearings, but as you know, they are in lightning rods for every interest group in the country to take positions with their own constituents. So the confirmation process has changed enormously since the days of the Warren Court. Fifth comment is that we now know a lot more about the justices and the work of the court inside, behind the curtains, than we would have known 40 years ago. I mean, it used to be, in the 60s, justices wouldn't talk to journalists. I, as a law clerk, wouldn't have dreamed of talking to a journalist. Today, I think it's very porous. We've had books like The Brethren, like Closed Chambers, like Jeff Toobin's The Nine, and so forth. These are kind of tell-all books, and you can read them and discern that a lot of people are talking, including some justices. Conference notes are now available for journalists to look at and reconstruct what happened in conference. Sixth, and I won't go into detail, if this were a law class, I would get more technical, but I will simply say there have been interesting changes in the process as cases go through inside the court, from the first filing of briefs to the final decision. To give you one example, in my day at the court as a clerk, each justice had 2 clerks, and those clerks wrote all the petition for certiorari memoranda for his justice. I mean, as the cases would come in, we'd write them up in little memos. Starting in the 1970s, they created what they call a cert pool, where you'd have a clerk write a memo for a number of justices. Now, that sounds kind of purely technical, and it is, but the dynamics of that process matter because it has actually changed, I think, ways in which the court thinks about cases. I'll comment seventhly on the decline in the number of cases. In the Warren Court, they used to hear and decide on the merits maybe 150 cases a year. It's now about half that number. I call it the great shrinking docket, but I can't tell you why. I mean, I've probed different theories to explain it, but it's simply happening that the court is taking fewer cases. Maybe they're spending more time on the ones that they're doing. Finally, a comment about law clerks. There's sort of a interesting thesis that the law clerks really write the opinions. I think that overstates the case. Clearly, they do a lot of the work. They have to. You can't imagine the justices doing everything themselves. No senior lawyer would do that on a major law firm. But it's interesting that to become a U.S. Supreme Court law clerk is a cachet. It's a wonderful point of entry into the world of law practice or law teaching or whatever. It's one of those little badges that you would like to wear. And the law clerks have, in some respects, become more diverse. There are now women law clerks, which there had not been at one time. There have been black law clerks, which there used not to be. But the one thing that has not changed is that overwhelmingly the law clerks come from elite law schools. You know, Yale, Harvard, Virginia, Chicago, those schools. But there is a profound change, and that is, when I was a law clerk, I think my politics and ideology was a matter of total indifference to Justice Black. He didn't care what I thought. Today, you're beginning to see more match-up between the ideology, political preference of the justice and the clerk who's being appointed, so that you have feeder judges at the Court of Appeals level who are known to be more conservative or more liberal, and they sort of send clerks along to the respective wings of the court. That, I'm not sure, is an entirely healthy development. Last thing I want to talk about is something about the Roberts Court. There's a convention, as you perhaps know, that you simply call the court by the name of the Chief Justice. That's sometimes misleading because the chief may or may not be the true intellectual leader of the court. But the Roberts Court is now 5 years old. And I actually picked up a book on child behavior this week. I was curious to know what behaviorists say about the behavior of 5-year-olds. But then I decided not to say anything about it up here because, you know, if I did, Chief Justice Roberts may see the video of this conference and I may never get to speak to him again. So I thought I'd forbear any analogies between the court and the behavior of people that age. But the Roberts Court has been there for 5 years now, so we can begin to make some generalizations about it. What happened is that in 2005, extraordinary series of events. Sandra Day O'Connor announced her retirement. President Bush said, I'm going to put John Roberts in that seat. Then Chief Justice Rehnquist unexpectedly died, and Bush then moved the Roberts appointment nomination over to that seat and then nominated Samuel Alito to the O'Connor seat. So by January of 2006, you had the first 2 Bush appointees on the court. Since that time, as you know, President Obama has put 2 more nominations on the court. So we have 4 vacancies filled since 2005. If you follow the recent term of court, the one that just finished this summer, the conventional view of that, and I think it's largely fair, is that there was a marked ideological split in the court. The most controversial case being the Citizens United case. That's the case that involves campaign finance. And it's clear that the court split 5-4 along ideological lines. So what can we say about the Roberts Court at the end of 5 years? First is the shift to the right. There have been 44 justices on the U.S. Supreme Court since 1937. And of the 6 most conservative justices of that 44, 4 sit on the present court. Now that's in terms of their voting patterns, and those are the 4 that I've just talked about: Roberts, Alito, Scalia, and Thomas. Now, I grant the shift to the right are episodic. Sometimes the liberals win a case or two, but more often not. Secondly, I see a strong correlation between the political parties, the president's political party who did the nominating, and the justice who's doing the voting. Now, that used not to be the case. There were some interesting surprises or shifts. Harry Blackmun, John Paul Stevens, David Souter, all appointed by Republican presidents who shifted significantly to the left wing of the court. I think those days are over. I don't think we're going to see surprises like that on the present court. I think you will find the justices of the present court much more predictable in their voting pattern than would have been in the past. Thirdly, I would submit that, remembering the activism of the Warren Court, that the present court is proving itself to be every bit as activist in a different direction as the Warren Court was. When the Warren Court and the Burger Court were in control, liberals were the ones who were the activists. They were the ones moving the law. Today it's conservatives, now that they have an emerging majority, they're moving the law. That should not really surprise anybody. So I think judicial restraint is a sometime thing, whether it's the Warren Court or the Roberts Court. Fourthly, a comment on Roberts himself. Increasingly, with this most recent term, it has become surely the Roberts Court. In the recent term, Roberts was in the majority 92% of the time. That's more than any other justice. And so I think we can begin to say it really is his court. Fifthly, a comment about Justice Kennedy. He's the one who's the man in the middle. He has the sort of fifth and critical vote that Sandra Day O'Connor used to cast. She's gone. He's still there. The difference is that, at least in her later years on the court, she was of a more moderately liberal persuasion, somewhere more centrist. I think Kennedy is really closer to the conservative camp on the court. He does at times sort of restrain the conservative majority. I mean, they can't just ride pell-mell into the sunset. They have to worry about his vote. So that does make a difference. Sixth, about the court's left wing. Not much change there. I mean, Sotomayor replaced Souter, pretty much the same voting pattern. She's voting along with Ginsburg and Breyer. I don't predict that Kagan's replacement of Stevens is going to make much difference. I think that side of the court is fairly stable. On the other side of the court, on the right-hand side, if you read about or read into U.S. Supreme Court opinions, you'll know something about Scalia and Thomas, who are famously willing to overturn both legislation and precedent. Thomas, in particular, almost breathtaking. I counted 6 or 8 different propositions in one term where he said if I had the votes, I would overturn them. I mean, he really wants to move, sort of slash and burn, move out. They are very conservative, but some would argue that Justice Alito, one of the newer justices, is in some ways even more conservative. If by conservatism you mean confidence in government and a narrow reading of the Constitution. Well, these are some of the characters. I realize if you're not a court junkie, you don't keep up with all the individual justices. And I have caricatured the court a little bit. There's a certain journalistic danger in attaching labels. I mean, first, conservative and liberal are very loose labels, and they're often very misleading. So when I talk about camps on the court, that is a simplification. Secondly, a lot depends on what cases come on the docket. I mean, the cases we tend to talk about and notice are the controversial cases like Citizens United. There are a lot of other cases that are more garden variety, which I think blur the picture a good deal. What I do think is going to happen in the near future will be that the court will be somewhat unpredictable, not only because of the mix of cases, but I think, as any student of group dynamics would tell you, it matters who the people are who are interacting. And when the court had that period of 11 years with no turnover, they settled into a pattern. Now they've got some vacancies, one more new justice arriving this fall, and I think it's going to take a little settling in time for them to get to know each other and decide how they want to interact. then I think we're going to settle in for a very long period. John Roberts is, I think, in his mid-50s. He's a great help as far as I can tell. Modern medicine is taking care of all of us. We all live a lot longer than we did. So unless he wants to step down, unless some sad accident happens, he's going to be Chief Justice for 30 or 40 years. So we're going to see a lot of the Roberts Court, and maybe you'll invite me back at some future day to look at the Roberts Court at another point. But I think that'll give you some picture of what it looks like now. I have talked here today only about the court. I would remind you, just as one footnote to this whole lecture, that it's easy to get preoccupied with the court and identify it with the Constitution. And I think I would add as one cautionary note that despite the importance of the court, the cases, the trends that I've talked about, there are two other branches, and they matter. And beyond the three branches, they're all of us, the American people. And I think that's the point you want to carry away on Constitution Day, is not simply what the Supreme Court does in interpreting the Constitution, but the extent to which it is in a way that is surely distinctive among countries of the world. It is more nearly the people's Constitution in this country than almost any other country that I can imagine. So thank you for being with me on Constitution Day.